As I said for the last Connects lecture, please feel free to ask questions. This will be much more interesting for everyone if you guys ask questions. So Allison mentioned my background. I'm an electrical and computer engineer out of Carnegie Mellon. Worked at Intel for 6 years. I went and got my law degree. Was a patent attorney for 7 years. Then got my MBA, and I've been doing venture capital or angel investing ever since. And so why Jason and I apologize, Jason couldn't be here today. He had a family emergency he had to address. But why Jason and I kind of brought this kind of topic to both BlueTree when we did it initially, and then more to Connects in the Swartz Center, is what we saw when we were working with BlueTree Allied Angels, BlueTree Venture Capital, Next Act, and a lot of the investment funds is a lot of investors said they wanted patents, or that they would more likely invest in a company with patents. And so what happened is a lot of companies went out and got patents, filed for a patent, had patent pending on something. But when asked, why did they get the patent? The general answer was because we were told to do it. Not because there was any strategy behind it, not because there was any need, not because they knew what they were doing with it. And two issues arose to Jason and I. First issue was a patent's a relatively expensive thing. It takes you $20,000 to get it, takes you $50,000 to maintain it. It's a lot of money for an early stage startup. And especially when you're talking about companies who say they have 8 or 10 of them, that's a lot of money to put into something where you don't have a strategy behind it. Second is there's a lot of other types of IP out there. And both investors and more importantly, startups were really focused on the patent side of it, not thinking trademark, branding, trade secret, know-how, customer list, all the other versions of IP and how they can be strategically used to build value in the company. And so we saw a huge mismatch here. And since we were both, coming from a patent background, we started talking to a lot of our companies initially, and then more generally to the general public about how do you develop an efficient IP strategy? What is it that you should be thinking about when you talk about IP? Patents being one, but what about the rest of the IP? How does your business strategy affect how you build your IP strategy? And one thing we'll talk about in the lecture is really business strategy should drive IP strategy. They shouldn't be separate. And more importantly, your IP strategy shouldn't drive how you're spending your money. And so that's what the whole purpose of this talk is really about, is to talk to you guys more about how do you think about IP strategy from a business sense? Let the lawyers deal with it from a legal sense, let the investors deal with it from a monetary sense. But when you're coming up with a business strategy, when you're thinking about how is the best way to use your money, how do you effectively build, or do you effectively build an IP strategy in it? Is it really worth the time, the effort, the money, the capital, the expense to build up these assets? And if so, one, how do you do it effectively? And two, how do you talk about it effectively to future investors and potentially eventually exit opportunities? How do you explain to them what it is that they are buying? And so the proof is in the pudding, as they say, and there's some links up there, and you guys can access the slide deck later on. But if you think of it this way, if you look at, let's say, the NASDAQ, if you look at the New York Stock Exchange, if you look at book value and you look at value based off of revenue, there's a lot of missing value, often termed as goodwill. Goodwill is IP in whatever form factor it is. That is IP. Goodwill accounts for almost 80% of the New York Stock Exchange. That is what we're talking about. And that's why we're talking about it here. And I jumped a slide. Okay. So that is what we were trying to talk about here. The big question for an early stage company is, okay, that's great for a major company. They can put it on their books and they can, compare it to what people believe, and, they're traded publicly, blah, blah, blah. How do I, as a small company, exploit it? How do I build an IP strategy? And that's what we're really going to talk about today. And here, I'm going to explain this slide, and then we'll stop for a second, and I'll ask, if you guys have any questions. But the key here is that you often have a business strategy. you often then use that business strategy to figure out what technology, what R&D, what research, how you're going to build that. That may then lead to, okay, the thought process, okay, I've got a great new technology. How do I do a patent strategy? What we want you to think about more importantly is, okay, let's broaden that. It doesn't have to be technology that only leads to patent. Well, maybe that. It doesn't have to be technology that only leads to IP. What about trade secrets? What about know-how? What about customer lists? What about everything else? Most importantly, what about brand? When we talk about IP, we often talk about patents, almost exclusively patents. Patents are good. They do a lot of things, but they don't do anything by themselves. Oftentimes when I talk to early stage companies, what I will hear is someone says, a patent allows me to stop someone else from doing what I do. And the answer is no, not really. The patent gives you the ability to sue someone if you have the money to stop them from doing what you do, but it doesn't allow you to do it because your technology might have been built on other people's patents. There's a lot of steps here. Understanding why you get a patent, what other ways you can leverage value out of that patent. How about, do you want a trade secret instead of a patent? What are the disadvantages of getting a patent? One of the big ones is, if I get a patent, I'm going to tell the world exactly what it is I do. That is the quid pro quo of getting a patent. Do you really want to tell everyone else what it is you do? That's a pretty serious question, especially if what you do couldn't have been figured out another way. And then does it really build value? Maybe it's not the technology you use that makes your solution so valuable. Maybe it is the way in which you address a problem. Philosophically, how you're approaching a problem that's very different from others. Maybe it is your sales tactics. Maybe it is the know-how of knowing whom to talk to and what the real problem is that actually allows you to sell your solution better. All of those come in and build into brand. The prototypical example of this is Coke. If you were to separate Coke right now, the formula of Coke versus the brand of Coke, which one is more valuable? And I think, it's relatively, the common answer is correct, which is, I can grab the formula of Coke and that's great, but that's not what I really want. If you're looking at the value of Coke as a brand, it's really all in the brand. The amount of money and effort and time they've put into building this brand around joy. That's where Coke, and so yes, they might have patents and they do have a trade secret on the formula, and they do talk all about how no one has ever figured out their formula and it's held in. All of that is more PR for building their brand than really affecting their trade secret. If they were to lose it, they would hate it, but it wouldn't kill the company. If they were to lose their brand, it kills the company. And because of this, a lot of large companies are really focused on how do they build their IP strategies. And why is this important to you guys? Because eventually, at least some of you are hoping to get bought by some of these larger companies. And if they're going to buy you, this is going to be part of why they buy you. Let's assume that you start making revenue. Let's assume that you're even profitable. In the long run, the amount of revenue you guys are building is likely very small compared to what your acquirer is likely making on it. That they're not buying you for your revenue. It might be a good source of revenue. Your revenue validates the solution. They're hoping to take your solution and blow it up. They want the IP. They don't really worry about too much about your revenue. But that IP value doesn't, as we were just talking about, come from the patents. It comes from the brand, it comes from the know-how, it comes from the trade secrets, it comes from how do you guys tell the story of your IP? Why did you get it? Why did you spend the money on it? How does it differentiate you in the market? How does that really create brand value? And this is good for you to know because it's going to affect your strategy moving forward, that a majority of the companies do see patents as a business driver. What does this mean for you, given what I just said, 10 minutes ago about the fact that patents aren't the pure way to get IP value? The fact is there's two different pieces here. First, you have to have a good strategy. Second, you have to be able to tell a good story. And part of that story in today's world has to include at least some aspect of patents. So for a lot of our companies, what we talk to them about is know what it is you want to patent, know what it is you want to keep as trade secret, know how you tell the story about both of those pieces. The patents are easy to validate when you're going through due diligence. The trade secrets really kind of pull at the heart of why you are going to be valued, where you're going to be valued. And it's the balance between those two, along with trademark, along with copyright, a lot of other things. And so in the past, we haven't talked much about copyright, but suddenly, if anyone's been following the news recently, copyright's become a huge issue. And where it's become a huge issue is in the large language models, the generative AI. Who owns the data that's used to train your AI model or the AI model that you're using? Let's assume for a moment that you're using ChatGPT. Let's assume for the moment, as is being threatened at least right now, that ChatGPT used other people's copyright material to train it. Are you now infringing their copyrights? That could be hugely detrimental to your business. The alternative to that is, everyone's saying, look, ChatGPT has indemnified me from any liability. That's true unless the liability exceeds their insurance and they go under, and then you are still on the hook for it. Maybe not. Maybe you're not so worried about that. You're a small guy, it doesn't matter. The bigger problem is what if the large language model or the generative AI model you're using goes down on you because of one of these issues? Copyright could very well be a way that destroys your business, or maybe more importantly, owning the data, owning the creative data that you use to train your own LLM puts you in a much better position to be around when some of the others start to falter. Owning some of the data and being able to leverage it and understanding copyright and how it's valuable, or having a good counsel to help you walk through that, along with trade secret, trademarks. So each of these types of IP, and we'll talk about that a little later, have their way of building value. And there's no one strategy that works for every company, but understanding how to talk about it is going to be hugely important, and then how to build a strategy around it. So what are we going to talk about? First thing we're going to talk about is, okay, I've talked a lot about the value of IP, but the first thing we have to avoid is, how do you avoid spending so much money on IP that you sink your company and end up with nothing of value? Once we know what to avoid, let's talk about what we can do to actually use IP to build value within the company, and then how we can make some informed decisions about what we do with the IP after we have it. So we want to talk a little bit about how IP can bring you down. And the first and foremost is, it is expensive. As I mentioned, a patent takes about $20,000 to get. It takes about $50,000 to maintain over the life of the patent. And that's not talking about anything other than just getting the patent. That's not policing it. That's not enforcing it. That's not doing anything but just getting the patent. More importantly than that, it costs time. You guys have to go and draft it. You have to take time away from your business, building your business, to go put all the documents together, all the information together, talk to the lawyers, get everything drafted correctly. It can just be very expensive. So everyone's like, okay, let's go to trade secret. That's really simple. No, trade secret is even worse. Trade secret, you have to have a secret that's valuable. Then you have to show me policies and procedures about how you keep it secret. So now I have to tell all my employees, you guys can touch this, you guys can't touch this. And then I have to police it. Who isn't allowed to make sure no one's going to. Then I have to start doing penetration testing, try to break down my own protection procedures and see that no one can actually break into it. I have to go all of that, and I have to document all of that in a way that then I can bring to the court down the road. So everything that we keep as a trade secret, as opposed to just a secret, is very expensive. So is it worth the cost? Branding and trademark. This is an interesting one. Getting a trademark is really, really cheap. Probably under $1,000, maybe even under $500 to get a trademark. Problem is the trademark is worthless until you start building value in it. A trademark doesn't have value until it identifies goods and really is associated with your brand. How do you do that? You need to spend a lot of money on marketing. People have to be able to tie that mark with your products and something about you. What is it that you want that mark to represent? That you are trustworthy, that you are efficient, that you are fast, that it is always on. What is it that you want that mark to mean? And then you have to spend a lot of time building value in that mark. Every time you're out marketing your product, you have to use the mark, and then you have to use the same words. So you start building value in it. The nice thing about trademark and patent is patent value tends to be linear. It just holds its value. It's good. Patents are what they are. Trademark value tends to start very low, 0, as I said before, and ramp up extremely fast to be extremely valuable if done appropriately. But again, it costs money to do it well. Trade secret, we talked about know-how. You have to know who has the know-how in your company. Is it your salespeople? Is it your engineers? Is it your janitors? Where is that know-how stored? One example of this one and how you can lose know-how is a company was bought by a PE firm, and it was a manufacturing company. And the manufacturing company bought the process, they brought everything, and then they sold the building to a competitor because they just wanted the trade secret. They wanted to know how to build this product better than anyone else could build it. And so they sold the facilities and everything else to another competitor because they didn't care about it. Down the road, the competitors started building their exact product basically as efficiently as they could. And they were actually experts in it. So they were actually more efficient. And so they got sued for violating trade secret. They were like, the PE company that bought the company said, there's no way you could know our secret and how to build our product unless you bought it from one of our employees, unless you stole our trade secret. And so the company that bought the building said, we'll show you exactly how we know how to do it. Come on into our building. And there on the wall was a list of the procedures about how to build the product. They didn't understand what they had just sold. They had just given it away. So it is something that requires a lot of effort, understanding, and it requires a strategy around it. And if you don't, you can lose it all. Before I go any further, any questions, anything I'm not being very clear about? And please feel free to interrupt me at any time. I do not mind being interrupted. It'll make things easier for me as well. This one goes more to the fact that I was talking about earlier, especially with trade secrets. Once you identify something as a trade secret, you need to protect it, and that costs money. You need to figure out just how secret it is, and then you need to figure out what would be considered the rule of reason. Rule of reason in the courts is you need to take all reasonable steps to protect that trade secret. The problem with that is no one says what is reasonable. So you need to go to an unreasonable level of protection to make sure that you're reasonable in front of the court side, because you don't know where that level or where that line is going to be drawn. And so it requires an unreasonable amount of protection. So typically when we talk about, say, computer programs, it might be storing that program on a computer where all the ports have been disabled, in a room that no one's allowed and no cell phones are allowed in that room. That may be the level of protection you need to put around a trade secret because it's very valuable to your company. There may be other secrets that are less valuable that you're willing to let go, that you take different levels of protection around. But it can be very cost prohibitive. So if you say every secret in our company is a trade secret, guess how much money you're spending protecting every secret that may or may not be valuable down the road just because you want to say it's a trade secret. Yeah.
Would you say that for a startup, something like an accelerated growth through excessive marketing would be much better than actually filing for patents and then going through the entire process to sort of save themselves from competitors?
So the question was, for a startup, wouldn't it make sense to spend that same amount of money on building the business rather than protecting what it is that you're doing, rather than spending the money on patents and trade secrets and everything I'm talking about? The answer is, in the short term, yes. But in the long term, You're looking to get acquired, you're looking to own a market, you're looking to do something. If you do not protect it, more than likely, at some point, you're going to catch the attention of a very large player in your market. And it will not be that hard for them to reverse engineer and do what you're doing. And for all intents and purposes, take your business from you. Without the IP protection, you don't have any way of stopping that. So what are the different types of IP? So one is patents. Patents are great, but as I said, you're disclosing to the public what it is you're doing. So why are patents valuable? They are not valuable to stop a competitor from doing what you want to do. Where they are valuable is in giving a larger player in the market confidence that if they were to buy you, they could stop their competitor from doing it because they have the war chest to actually fight the patent lawsuit. So it increases your acquisition value. What else is good about patents? There is technology out there that you want to get access to. There's technology that you have now that you've patented. Leveraging it for cross licenses or even licensing revenue down the road as other ways to build revenue. They can be, and we'll talk about this, they can be used as collateral for loans in order to allow you to build your business faster. Trade secret. Why do we go through the protection of why do we go through the effort of protecting something so heavily if we don't know if it's going to be valuable? Hopefully, we've actually built a strategy around what is and isn't valuable in our company. Down the road, again, acquisition. It is something that you can tell to a competitor or a potential acquirer. This is something we know nobody else knows how to do. And here is everything we've done to protect it so that when you buy us, you're getting all of this. You're getting this and you are getting full ownership. And here's how you know you're getting full ownership of it. And you'll be able to do this better than anyone else. Trademark. Why do we spend money on marketing? In the end, as I said at the very beginning, you're not being bought for your revenue. You're being bought for how well someone thinks that they can take what you're doing and do it even at a larger scale. For them to know what you're doing and to think that they can do it at a larger scale, they have to know who you are and what you are and what it is you guys really stand for. And that's where the marketing really comes in. That's where the trademark comes into play. And then finally, without go ahead, please.
So I just wanted to understand will this IP strategy evolve depending on the company's position and scale? Like probably you keep something as a trade secret and a year down the line or 6 months from now you apply for an IP depending on the circumstance?
Yes. So the question is does the IP strategy change over time? And the answer is yes, based on a lot of different things. First, on capital. The more resources you have, the more comprehensive of an IP strategy you can build. It'll also depend on stage of the company. So early stage companies, everything you've done is new. It's actually more available to patent. Once you sell something, you can no longer patent it. So sometimes it's actually advantageous to spend the money on the patent early on because you haven't sold it yet. So you still have that. As soon as you sell it, patent's kind of out of the question or can be out of the question. Then there's other solutions around what you can and can't do. So as you grow, you get more money to do more things, but you also get more limited in what you can or can't do down the road because of what you have already done. And finally, having a poor IP strategy can actually not only cost you money, it can destroy the business. So a lot of times you're going to hear, especially as a small company, a larger company coming in and saying, let's do a joint development agreement. Let's jointly own something. If Jason were here, he would tell you almost never do a joint development agreement. The answer is not don't work with other people. The answer is make sure you know what you own and they know what they own. The problem with a joint development agreement is the way that a lot of them are structured, especially if they're done by a large company that doesn't do this very often. So they're just using the form language that they've always used, is that it ends up being we both own it, which means let's say there's a third party that wants what we both own. First, they'll go to you and they'll say, well, I'll offer you X for it. And then they'll come to me and they'll say, well, they're offering me X for it. I'll offer you X minus 1 for it, and you'll get all the profit. Then they'll go back to you. They'll just work us against each other until we get to a de minimis amount of money. And they basically get it for free because neither of us has exclusive ownership of it. Second problem is one of us probably wants to do one thing with it. One of us probably wants to do another thing with it. Who gets to control where this IP goes? This can create problems for early stage companies when working with a larger company, you guys get, some IP with them, and then one of their clients, who's one of your competitors, wants to use it. They want their client to use it. You don't want their client to use it. Who has the right to determine who gets to do it? Who has the right to determine whether or not a litigation is initiated? Who has the right to determine whether or not we're going to file more and more IP off of this set of IP that we started with? Or are we going to just stick with it? Who's going to pay for it? Who gets the most value out of it? Without having all of that set up beforehand, by the time those decisions come in front of you, now your relationships aren't where they were before. No one's clear about who can do what, and that starts to create conflict that could have been avoided very early on. The other thing that comes up, especially for a lot of early stage companies, and things to think about, is if you have a secret, if you have a trade secret, especially if it's related to your technology, and an investor comes and says, I'm willing to give you, X amount of money. I'm willing to invest in your next round. I'm willing to lead your next round. Just tell me about your secret. The answer should be no. And the reason it should be no is as soon as you tell anyone your trade secret, guess what? It is no longer a trade secret. You've just lost it. Many companies don't realize that they've done that and do that accidentally all the time. Many investors don't realize that they're doing that when they do it. But if I were to come to you and ask you that, and you were to tell me, I can tell you what our secret does, and I can point you to our clients that can prove that our secret works. I just can't tell you the hows or the whys because that is what we own. And if we were to tell you it, we would destroy it. Showing that you know and have a strategy around it is more valuable than actually telling me what it is. Because as an investor, what do I really care? As long as the product works, my job isn't to worry so much about how you do what it is you do, just that it works, that it's going to scale, that we're going to grow a good business out of it. That is where you have to take ownership of your strategy and know what it is you're willing to talk about and what it is you're not willing to talk about. Okay, so I've given you the doom and gloom. Let's start talking about how we can actually use IP to drive some value in the business. First, there's a lot of different ways once you start to think about coming up with an IP strategy that you can leverage that strategy to improve where your business stands. Obviously, with fundraising, a lot of investors are going to ask you about patents. If you can say, look, we could have a patent, but instead we chose trade secret. Here's why this is a secret. Here's why this is going to be valuable down the road. Here's why you should invest in us because we made the right decision. We've thought about this strategically. It allows you to start to drive those conversations that allow you to show that you're thinking about the spend you're doing strategically and not transactionally. It opens up joint ventures. It opens up abilities for you to work with other companies to expand the reach of your products. Cross-licensing, PR. Should something happen down the road, if you've done your IP in the right way, it gives you a much better negotiating position. And finally, when it's time to get to the point of selling the company, having a good IP story that goes along with your business story, with your financial story, with your HR story, having this as part of that whole package allows you to sell at a higher price. And I'm going to jump back to the negotiating power. What is that? Why does that matter? So let's assume for a moment that you got a patent and eventually it got granted. And you're throwing your arms up in the air and you're saying, yay, I got a patent granted. 2 or 3 years down the line, someone comes to you and says, you're infringing our patent. Or you say to them, let's go the other way. We're infringing your patent. You go to the competitor and say, you're infringing our patent. And they say, and you're in a position where you can actually file a lawsuit and whatnot. And they say, that's fine. We're going to invalidate your patent in front of the patent office. If they do that, and that's going to cost them likely around $500,000, if you did the scenario I just suggested, you're dead in the water. There's nothing you can do to fix that problem. You've lost your patent, and now they can do exactly what you're doing without you being able to stop them. Go back 2 or 3 years when you got the grant that we were talking about and the patent was granted. If you had talked to your lawyers at that time and you said, okay, I've gotten this patent granted, let us file a continuation off of that and keep it alive in the patent office. Don't worry about don't worry about what a continuation means. It's a patent term, don't worry. But what it allows you to do is it keeps alive that asset in the patent office. So now you've got one patent that's been granted and the exact same body of language still alive in the patent office. Now we go 2 or 3 years down the road and someone comes up to you and you say, oh, you're infringing my patent. They say, sure, that's not a problem. I'll invalidate it. As soon as they figure out how to invalidate it, you've still got that live one in the patent office. You can come back and say, well, that's fine. If you do invalidate it, I can fix whatever problems you find with it and bring out another patent and then sue you on the new one that's even stronger than the original one. You've wasted $500,000 and I've wasted, let's say $20,000 or $30,000 to get the new patent out. And I've got an even better position than I had before. That puts you in a much better negotiating position to say, so don't even attack my patent. Let's figure out a licensing deal. Let's figure it out, because otherwise I'll just keep doing this to you. The more problems you find, the stronger patents I get. And so that puts you in a better negotiating position if you had thought about this strategically from day one. So we'll go through kind of these in a relatively quick order because I kind of talked to them. But yes, go ahead.
Do you need to pay, are there fees to keep it live within the office, all while continuing the patent through the years?
Yep, those are called maintenance fees. They come in at 3.5, 7, and 14 years after grant. And you do have to pay them. So that's why, and you have to do them for all of your patents. So that's why when someone comes to us and says that they have 5 patents, I start to get worried, especially for an early stage company, because I'm starting to add up those maintenance fees over the years and seeing that as a drain on their cash flows. As opposed to putting all 5 of those ideas into one application, filing one patent with 5 ideas in it, and then filing what I just called cons or divisionals, keeping it alive, and then coming to an acquirer. An acquirer says, okay, you've got one patent. I've said, no, I don't. I have one asset that has 5 different ideas into it that probably has 15 or 20 different patents, because I can connect idea 1 to idea 4, idea 3 to idea 2, 1, 2, and 3 together. I've got all these different ways to file more and more patents. I've got a whole thicket of patents here. One asset, lots of patents. That's what you acquire or buying me. And by the way, if you don't like some of these, you're not wasting money on it. You figure out which ones you want to go after, and I've left this all open for you, but here are all the different options in front of you.
Is there some kind of rationale for having 5 separate patents?
So, and we can talk a little bit about, and this is for patents, trade secret, even trademark. We typically divvy things up into kind of different buckets. So for patents, it's typically core, secondary, tertiary. Core are those things that you would never sell. Those kind of concepts, technologies, whatever it is around your company that is really core to your business. Putting them all into a kitchen sink patent kind of makes sense, because you were never planning on selling it. You can file a lot of different ideas of it. The other thing about the core, that core kind of kitchen sink strategy is, I don't know where your company, and you don't know where your company is going to be 5 years from now. It may have a different product that's based off of the same technology. By having one of these core patents, you can shift your claim sets over the years to follow where your product goes and make sure that you're always protecting yourself, and you're getting your protection all the way back to that base date of whenever you filed the very first patent. Secondaries are ones that are a little bit more interesting. Maybe you found them out by accident, but they're still good things, but they're not really core to your main technology. They may be good in a very specific field. They may be good in different ways, and they may be good to a lot of other players, where you might want to license that out for revenue. You might want to license that out to get access to other people's technology. Those are more technologies you can use, and you would spend a little bit less. So for the core, you'd spend a lot of money drafting that correctly. You may even go internationally on it. For the secondaries, you probably spend a little bit less money, a little bit more targeted, maybe even knowing who you're going to license it to. The tertiaries are kind of the ones that you kind of just found by accident. Maybe there were things you thought about as you were going through that didn't work for your product, but still are kind of might have been interesting to this other player in this other market that you'd want to sell it to. You might file something really quick and just offer it to them, and more as a revenue generating one. So each one has their own strategy. And there isn't any one strategy that's going to work for everyone out there. You have to think about what are your technologies, what are your options, what are your optionalities moving forward, what makes the most sense. If I'm going to spend $1 today, how do I get $5 of value out of it tomorrow? And that's kind of got to be your mindset about all of this. So we talked about this, investors love to see IP, especially patents. Patents are what they know. And it drives me crazy talking to investors sometimes because all they think about is patents. But if you can take an investor who asks you how many patents you have, and if you can take them from that question to, it's not about the patents I have. Here's my IP strategy. Here's what we have. Here's how we're protecting it. Here's why it's going to be valuable down the road. That allows you to build two things. One, the fact that you haven't wasted money on stuff that you shouldn't be getting in the first place. Two, it provides more evidence that you're thinking strategically, that you're going to be using their money that they're investing in you in better ways, whether it's for patents or for product or for marketing. The fact that you're thinking about it strategically, this is one more option for you to showcase strategic thinking to potential investors. And finally, down the road, especially as you get a little bit more mature and especially as your patents get a little bit older, there are companies out there that will allow you to monetize the patent. So they will give you a loan of a certain amount of money, and the collateral for that loan will only be the patent. And if you don't pay back the loan, they get the patent. Typically, they get to sue whoever they want based off of your patent until they earn the principal back, and then you get your patent back. So there's a lot of different companies out there that monetize patents in that way. So if you've got a well-drafted patent, that is one way for you to do that. And a little bit for trade secrets, but really that patent monetization is really just patents. The other thing is that for better or for worse, IP is related to successful exits. And the reason for that, and here I'm not talking patents, I mean IP as a whole, and it's really know-how. So goodwill, however you want to phrase it, think about it as we talked about earlier. You're not being bought for your revenue. You're really almost not even being bought for your product in such an extent as to how you're selling it today. You're being bought because some larger company sees some way that they can effectively take what you've done and do something much bigger with it. If they're paying you 10 million, it's because they see $100 million of value. If they're paying you 100 million, they're seeing $1 billion in value. That's what they're looking at in their terms of math. And one way of convincing them that you are worth what you are worth is having an IP strategy that says, yes, you can do that. Here is what we own. Here's what we've come up with. Here's what we are beyond just our product for you to take in many different ways. This is an interesting statistic. I don't know how valuable it is. I would still say the more valuable thing for you to have is a great IP strategy. And if it involves filing patents, then you do so, but do it well. Don't waste money just filing a patent for the sake of getting funding. It is a waste of money. It is a waste of effort. And in the long run, it won't work out in your advantage. So the other thing that patents provide is they are in some ways validation. They are a way of saying, look, the US Patent and Trademark Office has also said what we are doing is special, especially where you are inexperienced, either young and inexperienced, or you're just in a new field that you don't have the gravitas in yet to be able to command that kind of trust. You can say, look, you don't have to trust me. You can trust the US Patent Office. They did their searches and said what we did is unique.
So would you recommend that applying for IP is only beneficial once the firm has stable cash flows?
No. There are many companies that get sold for their IP before they sell a single product. The value you get from your IP is pretty much independent from the value you get from selling your product. Now, selling your product can validate that there is a demand for the solution, the philosophy that you're addressing. And depending on what the trade secret is, that there is a need for the way in which you're doing something that is relatively unique in the marketplace. So that there is value in having revenue as a validation of the IP. But if you're going to be bought on your revenue side, it's more than likely a financial acquirer, a PE firm, and they're looking at EBITDA multiples, they're looking at growth, they're looking at profitability. If you're going to be bought strategically, it's going to be based off of your IP. And those two numbers can be very different from each other, and they will be very different from each other. Yeah.
Why are patents particularly beneficial, but inexperienced entrepreneurs?
It's because it's validation. If I'm an electrical and computer engineer, if I say I have a new surgical tool, no surgeon's going to ever believe me. But if I have a patent on a new surgical tool, I can at least say, look, this is something no one else has done before. At least that's what the USPTO has told them. So it's validation when I can't just rely on my resume as validation that I know what I'm talking about. The other thing is that it helps towards exit. More importantly, once something is patented, I can talk to my investors about it. They can read the patent. That's all public information. I don't have to worry anymore about whether it's a secret, who can I talk to about it. It's out there. I can say, look at it. I can talk to you about it. It's all here. Here's the strategy we're going to talk about. And so I don't have to hide. I don't have to hide from my investors, and my investors don't have to hedge around the bushes, try to figure out what they can and can't ask me. The other thing is if you're going for SBIR funding, if you're going for NSF funding, if you're going for government funding in general, you're more than likely, you'll be more likely to achieve it if you have some patents or other ways of validating your product. And the SBIR is an interesting play, especially if you're a med tech device company, where you literally cannot sell your product because it hasn't gone through the FDA yet. And you have to have some way of showcasing that there is something real behind it all. And the patents can act as a surrogate for that. And it can lead to $1 million for SBIR 1 or closer to 2 for the SBIR 2 grants. We talked about the loan collateral. It's an interesting play. It's not for everyone, and it's not for every patent. If you're even thinking about this down the road, your patents have to be very well drafted, because the only way that a lender would ever even accept it is if they thought that they could win a lawsuit on it that would justify the amount of money that they're giving you. So it's an interesting play. It is something to talk to a lawyer about, if you're even thinking about this long term. And there are some examples of where it worked, and this is being done more and more often. But this is a kind of harder play just because it is easier if I'm an IBM with 1,000 patents or 100,000 patents to say I'll use 1,000 of these for a loan collateral than for a startup to say I have 1 patent and XYZ lender, this is a very valuable patent, and you can sue someone on it, even though you don't know anything about me and you don't know anything about the patent, you don't know anything about the industry. So it is something you need to think very strategically about if you're going to go down this path. Joint ventures are a great tool for you to increase your IP portfolio if you do it correctly. And here is where you often run into problems because you're often doing a joint venture with a larger company. And almost invariably, the first time you get a draft from the larger company, their draft of the agreement is going to be, we own all the IP. And maybe at some point, the second one is going to be, we both own all of the IP. But in the long run, you have to figure out, because they won't, you have to figure out who should own the IP, who has the most vested interest in taking that where it should go. As I said, if they have clients who are doing similar things, they're not likely going to want to sue their own client for infringing the patent with you. And they're likely going to stop you if they have the power from doing so. They may not want to spend money filing continuations and these other things I've been talking about, even though they could be very valuable because they already own the technology. They don't want to spend more money on it. They may not have a strategy around how to build an IP portfolio, or maybe they don't, maybe they want to throw the trade secrets into patents because they want more numbers or whatever else. Maybe they're not using very sophisticated legal counsel and they're just putting everything in there. And you're going to lose your trade secrets because they're throwing them into patents and making them public. You need to be very careful in entering these agreements, but they can be very lucrative because they give you the ability to leverage a larger player's war chest to help you bring your IP to bear. So again, it can be a great pathway for it and a great tool, but it's got its own set of minds that you have to worry about. And finally, cross-licensing, especially as you start to get further into the field and you start to think about, okay, we're starting to run into competitors. Who do we want to work with? Who would be good syndicate partners? And who do we want to stay away from? Who do we not want to have access to this technology? And then whose technology do we need access to in order to do what we're going to do, or to build our next tool, or to evolve into the next industry? And how can we leverage this in order to be mutually beneficial, to turn a zero-sum game into a win-win? That's where your kind of IP really helps you get around and start conversations with others who may have initially viewed you as a competitor and may eventually view you as a partner. One of the easiest ways to do this is called a field of use license. Field of use license is very simple. I have the patent, I can stop anyone from doing this, but I'll allow you to do it in this industry or in this geography, or with these other tools, or doing it in this specific way. I can cut out of what people can and can't do what they want. So for example, one of our companies is Aeronix. They do oxygen for pets. If Boost Oxygen wanted their technology, they could say, okay, you can have our technology for humans as long as you don't touch the pet world, and we'll just be the pet world. And that way we can generate revenue off of their sales and we still own what we really care about. So field of use licenses are probably one of the easiest ways to do the cross licensing or generating revenue from licensing agreements. And they can be used to drive value. And especially right now. So if you're talking to me right now and you're one of my portfolio companies, from especially BlueTree Allied Angels. So we have 56 portfolio companies. Right now, we're telling everyone it is a horrible environment to go out fundraising in right now. And it has been for the last year, and it likely will be for the next year. So for all of our companies, we're saying, look through your IP, figure out if you have options to license and generate revenue, because you then wouldn't need to go fundraising right now where you're going to get beaten up. You can actually generate some additional revenue that you can then use to continue to build your business without ever having to go back into the fundraising until you're ready for it. So it provides a great way to provide some decent revenue without you having to do a whole lot, as long as you are strategic about it. And finally, you're going to see this kind of all over the place. People talk about patent pending or patented technology. You see it in commercials all the time. It gives this indication of that there's value in your product, that someone has said it's valuable. The US Patent and Trademark Office, you've got a patent in it, it's safer to use. Whether that's true or not, it's a different story, but it does work as a PR tool to help with that. And that is more patents than trade secret. It's very hard to say my secret is what's going to validate that I'm doing so well, because quite honestly, you haven't told anyone what it is. And then we've talked a little bit about this. Having a good IP strategy also allows you to have a shield instead of saying, I'm going to go out and sue someone on my IP, on my patents, or whatever it happens to be. It allows you to say, if someone comes and sues us, they're likely doing that because we're in their space. If we're in their space, they're likely doing something that we've patented, and we can use that as a countersuit in order not to get into a huge legal battle with them, but to put us on even footing so that we can negotiate a deal that is more favorable to us and to them, hopefully. Hopefully we can turn this from, again, a zero-sum game into a win-win for both companies. You know, we'll work with you, you work with us, and we'll keep, you know, X, Y, and Z competitor out of the marketplace. So again, these are things that need to be used strategically, but open up strategic doors for you down the road. And then finally, when you get to the acquisition play, assuming you're building your company to be acquired, or that becomes a strategy down the road. We've talked about it a few times already today. When it comes time for that, having a good story about here's our patents around what we do, you can read them. By the way, you can read everything we put out there publicly. You still can't do what we do because of our trade secrets. And by the way, even if you did both of those, you wouldn't have our brand in our clients. Our clients really believe in us because this is what we're known for through our trademark. And if you really want to do what we do, we can give you all three today if you want to acquire us. And creating a story around that. And the story is going to look different for every company. Some companies are going to be very trade secret heavy. Some, especially consumer packaged goods or CPG companies, very trademark heavy. It's really about a marketing play. And then some that are really hardcore tech companies, think quantum computing companies, yeah, that's going to be a patent play. So the strategy about how you structure that story is going to be very, very unique to your company and your situation. And the fact is, this is proven by the data. The more IP you have, the more ability you are able to protect your own goodwill and to create your own goodwill, the higher your exit value is going to be. And we've got there's a lot of data out there that shows it. I think the easiest one is, though, just look at the goodwill in the New York Stock Exchange. If you really want to know how valuable IP is right now, look at the total value of the New York Stock Exchange against how much of that is purely goodwill. Okay, so we've talked about all of the ways that IP can kill you, all of the ways that IP can make you rich. Let's talk about how you make these decisions. So this is something Jason and I came up with. It is a relatively simple idea. And it is, okay, how do you figure out what IP you have? So we've talked a lot about all these different types of IP. Okay, what do you have in your company? We do this with a lot of our companies, which is get a whiteboard, basically draw this up on it. What is this saying? It's basically, and we use sticky notes, and there's a reason why we use sticky notes, and I can answer questions about that afterwards. But basically, you put this up on a whiteboard, have everyone in the company, independent of role in the company, everyone in the company write down everything they can think about the company that makes it unique. Technology, culture, brand, anything, trade secrets, whatever it is that they think is unique about your company, write on sticky notes. Then you take the sticky notes and you can kind of move them up. Does this sticky note lend itself to a patent? Is it more of a trade secret? Is it more going to the culture of the company? Should it be in the trademarks? Is it something that we should publish? Forget about patents. It's not valuable enough for us to want to file a patent on, but it is something we want to get there out on a white paper. We want to be known for it. Copyright, know-how, customer list, anything else. What is it that makes us special? Then we can talk about how and why we are going to protect each thing in each category. What are we going to do about it now that we've identified it? But the thing to remember is that none of these really have any value by themselves. The only value that the IP brings to a company is through its brand, and that's why brand's on top. We recognize brand through trademark, but brand is actually built through all of this. I can do this, see all the patents I have on it. I'm doing it very well, it's all patented. By the way, you can't do it as well because we're doing things that no one else can do, and we have great trade secrets. Think of the Coke. By the way, this is what our company is known for. This is our culture. This is why you should come to us, because we are hard workers. We're easy to work with. We will go above and beyond when a customer comes to us with a problem. Trademark. onward with publications, copyright, all of that, especially, as I talked about earlier, copyright now with large language models. What data do you own? How is that different than what other people, and have you really hardened it down? That allows you to kind of get an idea as to, okay, I've got these great ideas that I think should be patented. How do I know if it's going to cost me $20,000 to patent it or $50,000 to patent it? How do I know whether I'm going to get $500,000 of value out of it? Question goes up to brand. How much does having that patent affect how valuable your brand is to a potential acquirer? Does it help you build that brand story when you get to that point? If you're going to go IPO, does it help you build the story to your public, to the market, that this is a truly valuable company that's worth the premium that they're going to be paying for shares, premium they're going to be paying for buying the company, premium they're going to be buying your product in the marketplace? That's what you're really looking for in terms of how do you leverage the different types of IP we've talked about in order to build value in your company. The rest of this is, just my email address and everything else. So before we go on to that kind of stuff, any questions, any thoughts, anything I can do to help out for you guys? How do you build this strategy? What do you do with it? Where are you now? What is the next step? And the one quick answer is the next step is do not go to lawyers. And there's a reason behind it. I'm a lawyer, or I was at one point in my life. Lawyers are great at telling you what is or isn't legal. They're horrible at telling you whether you should or shouldn't do something. They're not built for business. They're not built for risk. They don't analyze things in terms of what's the reward and how much. They're like, is this legal or not? It's a yes or no, black and white world to them. And they're very good at it. But if you're asking for a business decision, if you're asking how valuable this is, they're not equipped to make that type of decision. So before you go to your lawyers, you have to figure out how valuable it is to you. How much are you willing to spend? How will that spend come back to you in terms of value to your company? Then it's time to go to the lawyers and say, here's the strategy. Here's what I want. Here's how much I'm willing to spend to do it. Can you do that for me? And then they can answer that question a little bit better. That's what they're built for answering. Yeah.
So, from your perspective of an investor, how do you as evaluate a patent or any trademark? Is it separate from the startup you're investing in the valuation of the startup and the business? Or is it like a combined valuation thing? And one is like for patent, but for like trade secrets, where you don't have much visibility about it, like basically how do you just navigate that situation?
So the question is how do I, as an investor, evaluate the IP strategy of the company I'm looking at, either with respect to the company or with respect to the IP itself? So the short answer is, I, as an investor, and most investors, whether they say this or not, evaluate the IP within the company. And the reason is that very few startups come to us and say, we have IP. They'll come to us and say, this is a problem that the industry is dealing with. This is the way in which I'm solving it. The philosophy, that's kind of the know-how. Here's why. So how do I associate know-how? We look at founder market fit. How much experience does that founder have living the problem that they're trying to solve? Why is that important? Because that means that they really know the problem. They've got some intellectual reason for wanting to solve that problem. So that's where that IP comes in. We'll look at the financials and what it's being, what do the financials tell us about how much it costs them to do it versus how much they're selling. That gives me an indication as to how valuable it is of what they're doing. Where's the margins? Why am I talking about margins when you ask me about IP? Margins come from IP. So I'm not looking specifically at what they say their IP strategy is, because most startups don't have an IP strategy. Or at least they don't have one that they've called out as an IP strategy. What they do is they have a strategy about what makes them unique. That's what I value. And then I can work with them on, does it make sense to use patents? Does it make sense to use trade secrets? They're already keeping things secret, so I don't have to worry about that one. How do they build their brand? What are they going to spend on marketing? If you're a B2B company, why are you posting things on LinkedIn? Do you really think your consumers are reading on LinkedIn? Wouldn't you rather be in trade journals? How are you being effective in using your time and money? That's how I evaluate IP, intellectual property, as opposed to the goods and the services that are being sold. And almost all investors are going to tell you the same thing. They may not use the words I'm using, they may not even ever talk about IP, but that's what they're kind of evaluating in the long run, is just how are the founders that I'm working with going to react strategically in light of the amount of money I'm going to be giving them. Yeah.
You mentioned that a lot of companies, they get bought out before they sell the product. Is there a difference between, that you've noticed, I'm sure there's companies out there that the whole strategy is to IP exit, and there's companies who want to go to market.
Yep.
What's the difference between those companies, and how do you which one would you invest in, the IP exit or that?
Got it. So the question was, there's two different styles of companies. Those that want to exit relatively quickly, maybe before they ever get to market, and those who are looking for an exit or an IPO down the road after they've started selling. How does the IP strategy, how do I value their IP strategy differently? How do I look at their IP strategy differently? And I will say it's not a lot of companies, depending on the field. So if I'm looking at pharma, if I'm looking at med device, a lot of them exit before they ever sell a product because it's expensive to get through the FDA. If I'm looking at software-enabled tech or companies like that, I expect them to be in market almost from day one. So they're going to be selling well before they ever get to an exit. So there's a little bit of a difference there. But in the long term, what we're looking for is, and especially our fund, although most funds, we are one that's really focused on exit. And so what that means is I want to know where you're trying to get to and how you're trying to get there. So if you are planning to go IPO, how do you get there? So your IP strategy is going to be different because you're trying to leverage your IP to build confidence in your product in order to get your product sales up fast enough to a high enough level that justifies the price of an IPO at whatever IPO price you want to exit at. If I'm looking for M&A, I'm looking for how are you leveraging that same IP strategy in order to develop confidence in your potential acquirers to do the exact same thing, buy you at a price that makes sense. So I'm looking at a different IP strategy. Are you trying to convince the buying public to buy your product? Or are you trying to convince the acquiring public to acquire your company? And how are you using your IP to do that? And you might be doing both. So most companies don't know which pathway they're going to go down the road. They may have one favorite, but no one wants to eliminate it, especially not early on, because you don't know where the world is going to go. And so it's kind of how do you balance those two or do both of them at the same time while you're trying to build a product, while you're trying to do customer discovery, while you're trying to do everything else that you're doing. How are you balancing your time with this as well? And so we want to make sure companies are, especially founders or early stage team members, are thinking strategically about this along with everything else. Yes, I could have the entire team spend 100% of their time on their IP strategy, and they would come up with a great strategy and waste all of their money and die on the ground. Like that's not very valuable. On the other hand, they could spend all of their money marketing and building a product only to have the big dogs take everything away from them once they figure out how to do it. Also not very valuable. What we want is a balance. What we want is a strategy. And this is just one of many strategies that a company has to work through. Financial strategy, go-to-market strategy, all of them kind of work together. So there isn't any one answer I can give you, except that depending on which strategy is preferred, how much effort is put into Are you trying to build a brand within the consumer public or within the acquirer public? Yeah. So that's a big question that I won't answer that one specifically because I don't think anyone has an answer for that specifically. What I will say is that in the long run, generative AI is a tool. What it and it, you know, for those who understand what it does is it takes all the knowledge that it can gather and tries to combine it to solve or develop some sort of solution based off of what is already known. So in terms of true creativity, it's not there. It can only do what has already been done. So the most common example of this is, let's go with ChatGPT. You know, what does ChatGPT do? A lot of people believe what ChatGPT does is it answers your questions. It takes all of the knowledge of the internet and gives you the best possible answer. That's not exactly correct. What it does is give you the most popular answer based off of what it's read. So if you ask ChatGPT, what is oat milk health? What you will get is a description of how healthy oat milk is. Oat Milk Health is a lung disease company that's working on lung cancer. It has nothing to do with oat milk. But ChatGPT will never realize that. It's just not built for that. My point is, you have to know what these tools are doing in order to understand how to use their output properly. Can a generative AI model create something on its own? Not really. Can a person use a generative AI model in order to find new and improved solutions to problems? Absolutely. So whether or not that new improved solution is authored by the generative AI or the person, that's for lawyers to determine. I'm not going to get into it. But at its base level, generative AI cannot creatively come up with something new on its own. It can only take what the world has already shown it and pull it together. It might be unique in view of the prompt you give it.
My own life or my own experiences of the that I put in my this, and I asked you to come up with maybe a book.
So the output would be copyrightable, but not by the generative AI, because the reason it came up with the story is because of the input you gave it. You gave it the creative, it created the story around it. The reason I'm being very specific about this, especially in view of IP, is right now, generative AI is in a state of flux. So if you're watching the world out there, and so I'm going to get a little bit off topic here, and I'll bring it back to this in a sec. There is a number of lawsuits against ChatGPT and others because they're using data that isn't theirs, that is copyright by other people. They're using other people's creative works to try to improve their models. This is being done by the Gentry Images or by the New York Times and whatnot. So if you're going to start talking about AI as part of your IP strategy or your strategy in general, you need to know how it works. One thing we've been telling a lot of our companies to do is own the data that you're going to use to train up your AI models and know what data was used to train any AI model you use for your product. So we tell all of our companies stay away from ChatGPT. Why? Because I don't know the liability that's going to be fed back into my company's pocketbooks because of what ChatGPT did to train up their model. I don't know where the law is going to come out, and that uncertainty frightens me. Going to your question, what will eventually be the end result of this, in my belief, is that the AI models won't own any copyright the people who created the AI models, the people who created the prompts that led to unique outputs, they'll own the copyright. But if you're using an AI model and you don't know what language was used to, what data was used to train it, you're taking a huge bet on whether or not you are actually infringing other people's copyright. And if you are, at the worst case, you're gonna have to pull all of that out of your tool and put in a new thing that may or may not work as well. So rather than having to go through all that effort, from the start, make sure you know what's going in and you know that it's safe to go into your product. And that is part of your know-how. That is part of the IP of how you build your product. How did you, if you're going to use generative AI, how did you select what it is that is going to be used to train the models, or which models you use in order to build your product? That know-how, that selection is going to be part of your IP as well. So I'm not sure if I answered it, but that's a relatively hot topic that we wanted to make sure we were clear about.